How do I get started with my divorce? Divorce is an unfortunate part of life. It is also a real possibility in most, if not all, marriages. When two people enter into a relationship which eventually leads into marriage, divorce definitely is not usually at the back of their mind. Statistics show that one couple gets divorced every 10 minutes. With a 2019 report showing that the number of divorces increased 0.1% from 50,314 in 2017 to 50,356 in 2018 in Malaysia. Malaysia operates a dual justice system by having both the civil law, which operates for non-Muslims, and the Sharia law, which applies to the Muslims. Here, we only focus on the divorce of non-Muslim, which is governed under the Law Reform, Marriage and Divorce Act of 1976. There are a few questions you have to ask yourself before you decide how to start with your divorce. First question, how long have you been in the marriage since the registration of the marriage? One can only file for petition for divorce only after 2 years of the marriage. If the marriage is less than 2 years, then a special reason is needed to file for the divorce, which you could consult your lawyer on this. Second question, whether there's any child born from this marriage. It is important to decide the best arrangement for the welfare of the child. There's issue of custody and access to the child for the divorcing couple to decide. Third question, whether you have expressed your intention to divorce to your spouse. Of course, it is important to know the response of your spouse on the divorce, and this is the main factor to decide which mode of petition to be adopted for your divorce proceeding. Fourth question, is there any agreement on the issue of maintenance to be given to the wife and also the child? Most of the time, the wife and the child are entitled to maintenance to sustain their living after the divorce. However, it is advisable to look for consultation from your lawyer on the issue of the maintenance. Fifth question, is there any matrimonial asset? Any agreed arrangement on the matrimonial asset? Basically, the asset acquired during the marriage could be roughly considered as a matrimonial asset. It has to be determined on its arrangement upon the filing of the petition of divorce. In the situation that 1. Your spouse has agreed to your proposal to divorce, and both of you have reached an agreement on the issue of 2. Custody, and 3. Access to the child, 4. Maintenance, and 5. Matrimonial asset, then you could opt to file the joint petition for divorce. Otherwise, if there's any disagreement on the conditions stated above, then it is a contested divorce, and you could only opt to file the unilateral petition for divorce, which further assistance from your lawyer is highly recommended.